Hi, and welcome back to our educational series with New Century Planning Associates. Bob, we have a great topic today, a super important topic for seniors, and that is smart estate planning. Too many people do not put an estate plan together. We're going to talk about this today, and they end up, well, they don't end up, but their family ends up in a pile of junk because a little bit of planning goes a long way here. Not terribly difficult to do, maybe a little heavy lifting in the front. But we have a super special guest with us today, Bob, and I'm going to hand it over to you to introduce her.
Thank you, Mark. We do. Christina Hardman-O'Neal is an elder care attorney and estate planning attorney for 25 years in New Jersey with the law firm. She's a partner in the tax and estate planning department of Davison, Eastman, Munoz, and Payon in Freehold. Christina, thanks for being with us today. Appreciate it very much.
Thank you for having me, Bob.
Great. You know, Chris, you and I have done some classes and things before, and we're always surprised, I guess Lou and I really are more surprised that even people with money, for some reason, 60-70% of the public never really gets around to doing their estate planning. Why do you think that is, and what can we do other than trying to educate people? Why do you think that is? Is it just the fact that people don't want to address that unpleasant subject?
I think that's part of it. I think people get, very busy in their daily lives, working, taking care of their family. And, a lot of times they don't take care of themselves, even from a health perspective. And so sometimes doing those documents that require setting aside a meeting with a lawyer and thinking things through. And sometimes it's difficult, to pick fiduciaries and decide which adult child will be in charge of your estate when you're gone. You don't want to cause problems in the family. So you think if I put it off, somehow it'll work itself out. Right. But that usually doesn't happen. It usually becomes worse if you don't put something in place.
Right.
Yeah, and I think a lot of it, Christine, has to do with the fact that people don't know what they need to put in place. It's not like you have to draw up a 400-page document, and maybe for some that have a tremendous amount of assets it's that way. But, for the normal, average Americans, there are certain estate planning documents that you must have in place. What are those documents?
So, yeah, I think, we call it estate planning, and that may be intimidating for people. It may sound like, well, that's only for really rich people. But really, we're talking about 3 or 4, fairly straightforward documents, depending on the complexity of your family. So the one is a will, of course, a last will and testament. One is a power of attorney, which helps you financially during your lifetime. The third would be a living will or healthcare proxy or advance directive to address your healthcare needs if you come to a point in life where you can't address them yourself. And then the fourth, which not everybody needs, but certainly it's a good tool in your toolbox, are trusts. And so those 4 documents form the basis of any good foundation estate plan.
Okay, great. I want to follow up on the idea of the will versus the POAs. The will is for when you die. The power of attorney documents are for while you're alive. You tell, when we do our classes, you tell a tremendous story. I shouldn't laugh, it's not that funny, about a person who didn't have a power of attorney. Can you tell the power of attorney story where it was a second marriage and the guy slips into a coma relatively young? He was 61 or something like that, right?
Yeah, right. So, unfortunately, having practiced for many years now, I've handled quite a few of these, but the one that always, sort of comes to mind because it's a common scenario. We had a second marriage situation, kids from a first marriage who were grown-ups. It was a long-term second marriage. The people loved each other and they all got along great. But when the father unfortunately had a series of strokes, one was very bad at work, and he wound up on life support and being unresponsive, there were no documents in place. There were no powers of attorney, no healthcare directives. He hadn't done any planning. And so with no planning in place, the hospital couldn't take direction and have anybody sign what's called informed consents, which are the forms you sign when you enter a hospital to authorize doctors to do certain things. And the kids from the first relationship were at odds with the second wife. The second wife wound up becoming my client. She wanted the husband/father to stay on the life support, The children wanted him off the life support. They felt that he had said he didn't want that to be. He didn't want to be in that situation. But there were no documents that said that. They were only reporting what he allegedly told them verbally. So when they were at odds and the hospital didn't know what to do, the hospital filed with the court and to have a guardian appointed to address these issues and for the court to make a decision on whether this man would stay on life support or not, which is a very personal and emotional decision. And you certainly don't want the court making that decision for your family. But in this instance, it had to be. So the court decided the man would stay on life support for the next, I think it was 6 or 8 weeks. And then the court would revisit it. Well, the man came out of the coma and was able to come off the life support in that time frame. But at that point in time, there were 4 lawyers involved who had to be paid. The hospital had a lawyer, the wife had a lawyer, which was us, the children had a lawyer, and the court appoints a lawyer for the incapacitated person. So that's 4 people. And when we went back to court to report the good news to the court that he had come off the life support and was in recovery, the court ordered that the man who failed to do the documents had to pay all the lawyers and had to pay for all the costs associated with his choice to not do documents. And so that was a really sad financial end to the situation, although it was a great healthcare end to the situation. But his family was deeply affected because at that point, he lost his relationship with his children who wanted to take him off life support. He didn't think that was very nice at the end of the day. And so it was very sad.
So if I understand this, for the sake of a small, inexpensive document that could have been sitting in a drawer somewhere, a healthcare proxy, he paid 4 attorneys, found out that his kids, the second wife was the champion, and then paid a ton of 4 attorneys unnecessarily. So I'm making light of it, but the truth is you and I always encourage everyone to please get these POAs in place. A durable power of attorney for running the show daily, and a healthcare which is specifically for medical reasons. Some story, I told you.
Oh, that's a great story. That is a great story. And deeply rooted in the fact that a little bit of heavy lifting on the front and not a great expense. And by the way, Christina, I'm sure that there are a truckload of stories like this that, in a variety of different scenarios that it could absolutely have been pushed aside if only a little bit of paperwork was done and a little bit of investment done to make sure that these don't happen.
Yeah, you mentioned trusts before, and I know there's all different types of trusts. Can you tell us a little bit, the most common types, a living trust, an irrevocable trust, one that we do, unfortunately, do a lot of these days is a special needs trust. I think if you could spend a minute or two and tell people what a special needs trust is for and what it can accomplish for them.
Sure. Yeah. Like I said before, a trust is just another tool in your toolbox. So not everybody needs a trust, but it's there for certain situations and certain families, and it is more common than not. So again, it sounds like it's a tool for rich people, and it's really not. It's a tool for a wide variety of reasons. So one of the things that you mentioned is special needs trusts. So for better or worse, here in New Jersey, we have very high rates of autism, Asperger's, mental health issues in young adults, dementia patients, on the opposite side of the spectrum. And special needs trusts can really help those people and their families navigate the high cost of healthcare these days. So for example, if you have, a young adult with autism who's not able to work when they become an adult, and you want to leave them an inheritance, you want them to be able to take advantage of whatever government programs are available for them because healthcare is so expensive and their needs are so expensive. But you also want them to have some money, maybe from your inheritance or for their inheritance for the special things in life, like a winter coat, getting a haircut, going on a vacation once in a while, maybe a handicap accessible car, a laptop, a cell phone. The kinds of things that the government doesn't pay for is what a special needs trust is for. Because if you leave an inheritance directly to someone who is receiving government benefits, you're basically cutting off their government benefit source and forcing them to spend the inheritance and then reapply for the government benefit program. when it doesn't have to be that way. They could have sort of two pots of resources available, the government resources and the family resources through the special needs trust. So that's just one, variety of trust. There are irrevocable trusts. A lot of times we use those for tax planning. There are trusts for minors, and we use the term minors sort of loosely in the profession these days because, years ago, people got married when they were 18 and had their own kids. Now, people are getting married more like in their late 20s. And so maybe your children, as they grow into young adulthood, aren't necessarily ready to manage a large sum of money as an inheritance. And so we can use a trust for your children, your adult children, to manage it for them. Because if we don't put it in a trust, then the second they turn 18, they're going to have full access to the money no matter how much it is. Could be millions, could be only a couple of thousand. Regardless of what it is, they're going to have full access. And any mistakes that young people make with finances, getting credit cards, bad relationships, bad business deals, any of those things, that you learn how to navigate in your 20s or maybe sometimes even your 30s, your money will be gone by then. But if it's in a trust and it's managed by other people who are financially responsible, the child, the young adult will have more ability to be successful in life using your inheritance and their own skills.
All right, two quick follow-ups on that. So a minor's trust isn't just for an 8 or 12-year-old. It can be somebody, you don't want to leave $2 million to a 21-year-old. If I got that, it would all be gone. So I hear you. The other thing is, it's unfortunate, but it's common today that we have a child, a grandchild, a niece or nephew, we're going to leave the money, but there's a substance abuse problem or there's some other problems. Is that a special needs trust or is that a spendthrift trust? Is it similar?
Similar, yeah, depending on the situation. We sometimes do a combination of spendthrift or special needs. Certainly not everybody who has an addiction problem winds up requiring government benefit programs, but a lot of people do, and that's what the special needs trust can address. But some people just need a spendthrift trust, meaning they're just not fiscally responsible. They have capacity, they're legally an adult, but they're living a lifestyle that renders them unable to manage large sums of money. And you certainly don't want your inheritance to be wasted on alcohol or drugs or, again, bad relationships, bad business deals. So a spendthrift trust can protect your loved ones from those situations until they reach a level of more maturity.
Excellent.
Thank you for that, Christina. My next question is about probate versus probate, and probate versus non-probate, rather. How beneficiary designations can supersede will clauses. In particular, how that works with retirement accounts, insurance policies, and how that factors into the estate plan.
So, one of the things is we call it an estate plan, and it really should be a plan. It involves all of your assets. So we live in a complicated world these days. We have assets that are going to pass through your will, which means they're going to pass through probate, and assets that are non-probate. Now, in some states, the theory is that you should try to avoid probate because some states charge a fee based on the value of the probate estate. And so you can avoid the fee by making things non-probate assets. In New Jersey, we're not really concerned about the surrogate's office charging a fee. It's a very small fee. It's not based on the value of the estate. Going through probate in New Jersey is a very friendly, sort of quick process. But we are concerned about making sure your whole plan makes sense. So we have to look at all of your assets, the assets that don't have beneficiaries on them, and the assets that do have beneficiaries on them, and make sure the plan is complete. So if, for example, in your will, you say, I want this part of my estate to go to my children in trust until they're 30, but on your beneficiary forms, you put their names directly, and you didn't say, I leave it to the trust for my children, then it's never going to get to that trust which will protect them. It's only ever going to go to the person named. And so that sort of defeats the whole purpose of putting all this planning in place. And we can make your plan complete if we have all the information on what assets you have, whose name is on it, who's the beneficiary, and how do we change things to make sure the plan you have in mind is the plan that actually comes to fruition when you die.
So there's a lot of coordination involved between probate and non-probate. Not so simple. You know, another thing that you and I see a lot, people, I think, are woefully ignorant of gifting rules and legalities. I'm going to give my daughter $200,000 for a down payment for her house. Wait a minute. The gifting limit is 17. The new one is $17,000 a year. Parents can split that. It's 34, but 200 is not 34, and so you want to explain why we should, that they don't always do it, we should follow the rules and file what's called a 709 gift tax return, right? Smarter?
Right. Yep. So, so the only way you get stuff, so to speak, or transfer things is in certain circumstances. So one is a gift. You know, I'm giving it to you because I want you to have it. It's irrevocable. It's yours now. One is a loan. One is because I did a job and you owe me money. So there are certain ways to get things. When you make a gift, or actually I should start by saying, when you put someone's name on your bank account, on a house, on a stock portfolio, if you put them on as an owner, you've made a gift. So again, if you look at your numbers that you're using in 2023, the annual exclusion is $17,000 per person. But if it's more than that, you're obligated to file a federal gift tax return reporting the gift that's in excess of the $17,000. And that gets sort of bypassed sometimes as families because they're unaware of that obligation. But there are real penalties for failure to file if you make these gifts and you don't report the gift. So it's important to understand why you're doing things. You know, I have some people that call here and say, oh, I'd like to put my son on my house. And I ask them why, and they don't know why. They heard they should, but they don't understand why. And when I explain that, for some people, it's appropriate to put your adult child's name on the title to the house. And other situations, it's not appropriate. When you put their name on the title as an owner, they own it with you. So any creditors that eventually chase them or are chasing them now, divorces, any of those kinds of things are going to affect your asset because you put them on as an owner. We can do certain trust planning that maybe accomplishes the same goal of transitioning the house to your loved ones when you pass away, but doesn't put you at risk while you're living. So gifting is complicated, and it should be, really considered and not just done in sort of a quick, nonchalant way. It's not really a nonchalant thing that you should do.
That was my point. But a lot of times people don't realize they should do it correctly, legally, and they just give large gifts. And most of the time they don't get caught, but we know they should be a little more careful.
Christina, such great counsel. What if I have assets in different states or countries? What do I need to do there?
So, the probate rules go. We start with the theory that you have to look at your domicile, right? So some people decide that they want to be a Florida domiciliary for income tax purposes, but then they don't realize that maybe they don't really like the estate laws in Florida, because Florida is one of those states that charges a percentage of the value of the assets, in terms of probate. So you have to be careful with where you're saying you actually live and versus where you actually do live. We have a lot of snowbirds in New Jersey. And again, it shouldn't just be thought of in terms of income taxes. These decisions should be made in a more comprehensive way based on death planning, life planning, family planning. Some states have more friendly Medicaid laws than other states. Those are things you should consider. But in general, every state has reciprocity with the other in terms of your will, for example. So they should honor the will you drafted in New Jersey, although it may not accomplish the same goals in that other state. It will be admitted to probate if it's done properly in New Jersey. It'll be accepted, but you may be missing out on some opportunities for planning that are available in that other state that maybe aren't available here, or vice versa. So before you make a big move, unless it's absolutely necessary for a job or something like that. But if you're doing it for planning purposes, you should really consider all of the issues that could affect your family, not just, for example, income taxes.
So to follow up on that, if I have assets in more than one state or country, a will, that's called ancillary probate, right? I might have probate things going on in different states. Then you typically use a living trust to avoid the ancillary probate, right? The living trust can you explain how that can be useful when you have assets in more than one location?
Sure. So if you say, you live in New Jersey, but you own a home in North Carolina, but New Jersey, you've made New Jersey your domicile, you're domiciled here, you passed away here, for example. If you own property in another state, you're going to have to go through probate in 2 states, unless we put your out-of-state property in a revocable living trust, and then we can avoid double probate. We can avoid probate in the other jurisdiction. And some jurisdictions are friendly, like New Jersey, and some are not as friendly for the probate process. But it does save some money at the end of the day, and sort of provides a continuity for your heirs if you use a revocable living trust for your out-of-state property. Now, foreign countries is a little bit different, because we have to first look and see what treaties does the United States have with the country you're intending to go to, and how best to plan for that sort of cross-border living arrangement.
Okay. And a living trust, my understanding is that's a private document. A will is a public document, if that matters to the people.
Yes and no. So a will ultimately gets filed in the surrogate's office when you pass away. A revocable living trust generally doesn't get filed in the surrogate's office. However, there's a misconception that a revocable living trust is like locked up and no one could ever read it or see what it says. That's not true. If you've decided, for example, that of your 3 kids, you're going to cut one of them out of your estate plan for whatever reasons you want, and you put it all in a revocable living trust thinking that they're never going to see it or know about it, that's not true. When you pass away, they're entitled to know what you did. They're not necessarily entitled to undo what you did, although they may try, but they're entitled to know what you did. They're entitled to know, what was your thinking process? Were you under undue influence at the time? Did you have capacity when you did it? What was your thinking process at the time? And maybe they decide they're not going to fight what you did, and maybe they decide they are going to fight what you did, but it's not necessarily totally private if you've decided to, for example, cut out one of your children or your spouse or anything like that.
Okay, didn't realize that. You have another question?
Yeah. Divorce, that's going to change the estate plan quite a bit. What are the changes one should expect with that?
New documents, right?
So, divorce complicates your life, as everyone is aware. It's not just an emotional time in your life. It's also a time to really look at your planning, look at what you're going to end up with at the end of the day in terms of the divorce, and then plan accordingly. So the estate plan you put in place while you were still married probably involved your spouse. Maybe it didn't, but maybe it did. And when you're no longer married, you should revisit your will, your power of attorney, your healthcare directive, especially the documents that are going to affect you while you're living. If you're laid up in a hospital, certainly wouldn't want your ex or your soon-to-be ex making medical decisions for you. Now, there are laws in New Jersey and in most states where once the divorce is finalized, the divorce revokes, certain beneficiary designations, certain appointments of fiduciary. But while you're going through the process, you really should talk to your family lawyer and your estate planning lawyer about changing what you can while you're still married but separated, because it's the actual divorce document that will revoke certain things. But while you're going through the process, if you pass away, it could get very messy. And I've certainly handled a couple of those too, where people die midstream. They don't have the final papers, and then the families are fighting over, what's going to go on next.
And some divorces can take a long time. So change beneficiaries, change documents, consult. Last question. And you and I have had this conversation before. These days, people have lots of passwords and electronic assets, maybe digital assets even. They can't forget to include those in their estate planning, including the access to these documents, if a lot of stuff's locked up on the computer and somebody doesn't have the passwords or the digital wallet keys, can you just talk about how, I know you've added this as an aspect of your estate plans because everything's so digital and electronic lately?
Yeah, years ago, when someone died, they would come to their lawyer's office with boxes of mail. And we would say to them, well, just keep an eye on the mail and keep collecting all the data that comes in, and then we'll go through it and figure out what there is. But now even your mail doesn't come. It all comes to your email, or you have automatic billing, or automatic withdrawals from your checking accounts. So whether it's a cryptocurrency or your Facebook account, this is a famous one these days, is all my pictures are on my Facebook account. I don't have any pictures, or my family doesn't have access to the phone because the phone is locked down. The phone only took a fingerprint, doesn't take a password. There's all kinds of things that go on. And if you want your loved ones to have access to these things, you should certainly keep a list. Now, I know it's from the IT perspective, it's faux pas to let people know what your passwords are and write down passwords, and you should just memorize it and that kind of a thing. But when you pass away, some things are never going to be retrieved again, like pictures and sentimental things, not just, the cryptocurrency keys and the banking keys. Even if you were to become debilitated with a stroke or, dementia or ALS or those kinds of horrible illnesses, while you're living, especially, you want people to be able to access your fiduciary, at least, to be able to access your online bill pay. You want to either be able to stop certain bills or continue to pay other bills. So it's really important to keep your passwords and the keys to the cryptocurrencies and those kind of things accessible, not to hackers, of course, but to the people you've picked as fiduciaries. And certainly, lawyers keep those things in their safes. We encourage our clients to have a flood-proof, fire-proof place where they're going to store these things. Any updates in passwords, you should update your list. There are ways to do it, but it's important that you think about it and have some kind of plan in place.
Great. So thank you. These are some smart steps in modern estate planning. Everything's changing.
Hey, Christina, can we have you back on the program sometime?
Sure, I'd love to.
All right. Hey, thanks for being with us today. If you want more information about this, just give us a call in the office at New Century Planning Associates. We help you retire well.